Hello, YouTube. I'm Vince White. I'm an employment attorney. An actual, honest-to-God employment attorney. We still exist. On this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We've got a question here for YouTube user Taco Reacts, and I'll be honest, Taco Reacts sounds like they might be a fake version of a big influencer account from TikTok, but I could be wrong. I don't know. And their questions appear to be real. So the question is as follows. Hey Vince, got a question. Got an answer. If an employer has that discrimination is to be internally investigated. Okay, so I guess if they have a policy that a complaint of discrimination would be subject to an internal investigation, would not doing an investigation and not having any paperwork once they receive the charge be something you bring up during the investigatory period with the agency? So I assume like the EEOC or a state agency. Yeah. So a departure from a standing policy is beneficial to you potentially, right? If your employer has a standing policy like, hey, if you bring a complaint of workplace discrimination or workplace sexual harassment or some kinds of retaliation, we're going to perform an in-depth internal investigation. And then you take them up on that policy and say, hey, I'd like to make a complaint of workplace discrimination. And they tell you, no, we're not going to do an investigation. That departure from their policy is meaningful as a data point in your case. No question. Now, it's not a smoking gun. It doesn't prove the underlying discrimination occurred. It could be evidence of some form of retaliation, like they refuse to take you seriously, right? But just because it's not a smoking gun doesn't mean it's not useful, right? I mean, listen, very few cases have one piece of evidence. Un evidence is generally not going to be sufficient to prevail in a case like this, right? And listen, that's all situational. It all depends on context. There's certainly cases where you have the closed caption footage of the bad actor doing the bad thing, and you got the video, it secured the video, you keep it in a special briefcase with little copies all over the country just in case somebody gets to it. And then, that's your case because it's the bad guy doing the bad thing, right? That happens, but it's rare. Generally speaking, a case is made up of multiple, myriad pieces of evidence that are put together to support a narrative of your client's testimony. And your client's testimony is probably the key piece of evidence. And people always ignore the testimony, right, of the actual victim. They're like, oh, well, that person's got an ulterior motive. Or that person was there for all the bad events because all the bad events were done to that person, right? So you give your testimony, your client's narrative, and then you plug in pieces of evidence to bolster, support, build a foundation under, and rise up your client's testimony, right? That's the most common tactic you would see in this field. And so when I say that something's not a smoking gun, but it is useful, think of it as a support beam under the bridge of your narrative, of your testimony, of your story that you will share about how you were wronged. And that is valuable. The last time I checked, bridges tend to need a little bit of support. I guess not all of them. But the bigger the bridge and the more weight you want it to carry, whether that's cars and trucks or weight in court. Oh no, that was terrible. That was not good. But if you want a bridge to carry weight, you give it supports. If you want a narrative to carry weight in court, you give it supporting evidence. It's that simple. Oh God, that was a terrible. I thought it was so clever. I thought that up on the fly, and I was like, "This is gonna be great." I'm going with it. This is going live. If this was helpful, like, subscribe, comment down below, share the channel so it may grow. Take care, everybody.